Welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal of Asda Stores and Brierley and others. This is an equal pay case where the claim is brought by supermarket employees of Asda, and the question before the court is whether they are entitled to compare their pay with that of other employees of Asda who work in distribution depots. The supermarket employees being predominantly women, and the distribution depot employees being predominantly men. I'm hearing this appeal with Lord Hodge, Lord Lloyd-Jones, Lady Arden, and Lord Leggett. The parties are represented by Lord Panic, Queen's Counsel on behalf of Asda, and Andrew Short, Queen's Counsel on behalf of the employees. We're currently just reaching the end of the submissions on behalf of the employees, so I'll invite Lord Panic now to resume his submissions.
Thank you very much, my lord. Good morning, my lords, my lady. Very briefly, can I just complete my submission on the Tesco case? We've now seen the letter from the Court of Justice for the EU. We've asked for it to be sent through to your lordships and your ladyship. It may have arrived.
Yes, we do have it now, Lord Panic.
I'm very grateful. The court will see that it's sent to Lee Day, amongst others, because Lee Day are the solicitors for Kay, as well as for the claimants in the present case. And we received this from Lee Day this morning. The court will see the two bases on which the Court of Justice is proceeding. Article 76 of the Rules of Procedure, which allows the court to proceed without a hearing where it considers that it has sufficient information to give a ruling without the Advocate General's substantive involvement, and Article 20 of the statute, where the court considers the case raises no new point of law. So we will hear from the Oracle, from the Court of Justice, no doubt in short course. They will provide the answer. There would, in my submission, be no value, equal or otherwise, in me providing submissions on this point, or indeed inviting the court to make a reference. That is my submission. If I can assist further, I will happily seek to do so. Thank you, my lords, my lady.
Thank you very much, Lord Panic. Mr. Short.
My lords, my lady, good morning. I'm going to follow a similar pattern to my learned friend Lord Panic and deal first with the domestic law, and then this afternoon I will deal with EU law, but in the light of the position taken by the Court of Justice yesterday, I think my submissions there will also be shorter than otherwise they would have been. First of all, though, I'd like to deal with the question of the type of establishment, because the main authorities have all dealt with and permitted comparisons between different types of establishment. Leverton involved a claimant who was employed as a nursery nurse in an infant school, and she was held to be entitled to compare herself with men working in the county secretary's department, presumably in offices, and others in the library and museum departments. British Coal against Smith, which is a case that is referred to in some detail in the parties' written cases, but which the court wasn't taken to yesterday, and I will look at it in more detail. But British Coal involved comparators who, save in one case, worked at collieries. They could be relied upon by the claimants, who were spread across 47 establishments, but only 39 of those establishments were collieries. There were 8 other establishments. Now, that's not apparent from the report of the Appellate Committee's decision that it does appear from the EAT decision in that case. And we've given the detail of that in a footnote, footnote 10 to our written case, which is at MS page 120. I'm not going to go to that now because I think it is tolerably clear, but the point is that the claimants from the 8 non-colliery establishments were able to compare themselves to comparators working at collieries. Most recently, in North, this court dealt with claimants who were working in schools. Comparators were employed at various different types of establishment, including refuse depots and a swimming pool. And the court held in the course of its judgment, and this is at paragraph 34, but I'll come back to it in more detail later. The court held that the object of the legislation was to secure equality as between different jobs of equal value. For example, clerical workers in an office and factory workers in a factory, even if they could never or would never work in the same establishment in practice. Now, I will come back to this, but any approach to section 1.6 that tends to bar comparisons between different types of establishment does not sit comfortably with the purpose of the legislation as identified in North. And this ability to make comparisons between different types of establishment is essential to furthering the purpose of the legislation, which is to prevent sex discrimination in pay, because of the role that job segregation plays in sex discrimination in pay. Now, we have made some references in our written case to some reports on the topic of job segregation. And if I could ask my lords, my lady, to look at MS page 115. We have set out there at paragraph 24 some extracts from a report that was presented in 2006, the Women and Work Commission report, Shaping a Fairer Future, which highlights that a prominent cause of the gender pay gap is that women's work is undervalued. And we've set out, I think, 3 extracts from the report. We've given the references to the document itself, but it's convenient perhaps to take them from the case. And it says this: women and men tend to do different jobs, a pattern which is referred to as occupational segregation. Women tend to work in lower paid occupations, in particular dominating the 5 Cs: caring, cashiering, catering, cleaning and clerical. The occupations which are regarded as women's work are undervalued. Then, in a later section, wages for women operating the cash tills in the supermarket are lower than for men handling the goods in the warehouse next door. And then finally, and we say this is important, few organisations have gender inequality deliberately built into their pay structures, but such discrimination does exist and can stem from a range of causes. It is most likely where there are different pay structures for different groups of staff. And so we say any approach to section 1.6 that prohibits comparisons either across different types of establishment or across different pay structures is inherently likely to frustrate the purpose of the Act. Now, these concerns have been reflected in the case law. And again, at page, in our written case, this time at page 116, the following page, we've set out two extracts from Mrs. Justice Cox in Armstrong against the Ministry of Defence, a different Armstrong to the one we looked at yesterday. But paragraph 34, pay discrimination is frequently systemic in character, arising as a result of gender job segregation or from discrimination in pay structures and grading systems, rather than from the terms of individuals' contracts of employment. It's important, therefore, to understand how domestic and European equal pay law knits together so as to prohibit pay discrimination of this kind. And she goes on later, paragraph 46, the fundamental question for the tribunal is whether there's a causative link between the applicant's sex and the fact that she is paid less than the true value of her job as reflected in the pay of her named comparator. The link may be established in a variety of different ways, depending on the facts of the case. It may arise, for example, as a result of job segregation, or from pay structures or pay practices which disadvantage women because they're likely to have shorter service or to work less hours than men, due to historical discrimination or disadvantage, or because of the traditional social role of women and their family responsibilities. Now, the claimants say that it was a combination of these factors, including some stereotypical views as to breadwinners and second incomes, that resulted in their being paid less than the true value of their work, as reflected and shown by the pay of their comparators. Now, of course, all of this is in issue. No findings have been made as to the reasons for the disparity in pay. But the claimants should have, in my submission, the opportunity to prove that the disparity is discriminatory, did arise from these reasons, because if it is caused by sex discrimination, then it is exactly the target of equal pay law. Now, before I turn to the cases, I'll just give a short overview of our analysis. And we say the cases always deal with two questions. The first is between whom must terms be common? And the second is what is meant by common terms? And each question, we say, has two alternative satisfactory answers. The first question, between whom, has two alternatives. Either the terms must be common generally across the two or more establishments, and that means common generally for all or most employees across those establishments, or alternatively, they must be common between the relevant classes at the two or more establishments. And they are alternative, so that if you can show one, you don't need to show the other. And in most cases, if you can show that common terms were observed generally, it will usually follow that they will also be common between the relevant classes. That's not always the case. And you could have a situation where, for example, there are two establishments with 100 employees and 99 employees in each establishment are on the same terms. So there you will have, that will be enough to show common terms generally. And if the claimant and comparator are each the odd one, their terms won't necessarily be common, even though at the establishments generally common terms are observed. Now, the second question, what is meant, again has alternative answers. In the Leviton type case, you can have a common collective agreement, i.e. the genesis, the source of the terms, is the same. And in these cases, the terms do not need to be broadly similar. They can be very different amongst the parties, provided, or the relevant people, provided they come from the same collective agreement. An alternative is the broadly similar approach, which is found in British Coal and North. And in the cases, this broadly similar test has been applied to see if a comparator at establishment A is on common terms with a comparator or a person doing the same job at establishment B. But there's no reason why this approach, the broadly similar test, has to be so limited, and it can also be used to see if employees at A and B are on common terms generally. And to illustrate that with an example, one may have two establishments which have the same terms, not as a result of a collective agreement, but because the employer has given people the same terms, but they are identical or more or less the same in terms of pay, notice provisions, hours, holiday, and etc. But if one of those establishments, where everyone who works there is male, receives a bonus, and the other establishment, which is entirely female, does not get a bonus, as a matter of fact, it is the case, in my submission, that broadly similar terms are observed across the two establishments generally, because, save in one respect, as a matter of fact, broadly similar terms are observed, and it would be fair and appropriate for the purpose of identifying possible sex discrimination for that comparison to be made, subject, of course, always to the employer's right to show that there was a genuine material factor justifying the provision of the bonus in one case, but not the other. Now, I'm going to turn to the cases, and to start with Leviton, and the judgment in that case begins at page 588. The focus of this decision was the between whom question. The courts below had held that a broad similarity was required as between the claimant and comparator, and that was rejected, as my lords, my ladies saw yesterday, for two reasons. First, it ignored the fact that the statute required commonality generally or for relevant classes, and that's a point made at 591 between F and G. I think the exact words are that that phrase was given no content if one required similarity between claimant and comparator. But Lord Bridge goes on to say it would frustrate the purpose of the legislation. And it is understandable, self-evident perhaps, that the Appellate Committee rejected the notion that an equal pay claim could be defeated by differences between the claimant and the comparator. But what this case does not say is that it would not be sufficient if, on the facts of the case, it were possible to establish that common terms were observed generally where all or most of the relevant employees at the two establishments were on broadly similar terms. Lord Bridge wasn't dealing with that situation because it simply didn't arise on the facts. And when he got to the question of how are common terms established, a very straightforward answer was provided by the single collective agreement. Now, I do need to deal with the examples given at page 592. And these are between C and G. And this includes, this starts off at C, saying there may be perfectly good geographical or historical reasons why a single employer should operate essentially different employment regimes at different establishments. And although that is perfectly appropriate to introduce the examples, in my submission, Lord Bridge was not intending to provide an all-purpose alternative to the statutory test, to use Lord Justice Underhill's phrase, but was simply illustrating why his two examples worked. And the first of those examples is entirely straightforward. It is where the disparity is caused by geography and not sex discrimination. And that is made explicit by Lord Bridge at E, where he says, if the women in Newcastle could invoke Section 1 of the Act of 1970 to achieve equality with the men in London, this would eliminate a differential in earnings, which is not due to, or which is due not to sex, but to geography. And that is obviously outside the purpose of the legislation. The second example, which refers to historical reasons, I say with respect, must be treated with some care, and it is noteworthy that in North, Lady Hale referred only to geography rather than historical reasons. And although it's not expressly stated, in my submission, it is obviously implicit that Lord Bridge was referring to circumstances where the historical reasons did not involve sex discrimination. Otherwise, it would frustrate the obvious purpose of the legislation, because there will often be historical reasons for sex discrimination. And that's why, at a later stage, one cannot simply rely on historical reasons to provide objective justification for differences. And we've given a reference to a passage from the Advocate General in Enderby, which is, I think, worth looking at. It's at MS 1288. And although this is obviously a matter of European law, the analysis is of general application. And paragraph 49, to begin with, the Advocate General deals with the suggestion that carrying out negotiations separately can provide justification for a difference in pay. But the passage I refer to begins, that I'm particularly concerned with now, begins at G, where he says, in particular, references to historical and social reasons cannot, in a case such as the main proceedings, be recognised as factors which are objectively justified and unconnected with discrimination on the grounds of sex. See Bilker-Kaufhaus. The historical and social context of a purely female profession is most probably sex-related. If an explanatory approach were accepted as sufficient justification, that would lead to the perpetuation of sexual roles in working life. Instead of the equality of treatment which is sought, there would be afforded a legal argument for maintaining the status quo. And that, I say, applies equally to the domestic legislation, and the example given has to be seen in that context. The example straightforward: immediately after a 2p transfer, there won't be common terms and conditions, and indeed there may well not be a single source when we come on to European law. But Lord Bridge wasn't dealing with internal arrangements within a segregated workforce. Now, I want to make some general comments about separate regimes, because it is not the general approach of the Act to prevent comparisons between separate regimes. If one's dealing with the same establishment, the employment regimes can be as different as anything, and that's entirely irrelevant to this same employment comparability question. Common terms only become relevant where you have separate establishments. And I say that shows that the concern is the geographic separation, the possibility of geography explaining the differences. Now, common terms are used to address that concern, but they are not the rationale for it. They are the means, not the end, and it's not the purpose of the legislation to focus upon that. Because even when common terms are engaged, it is, in my submission, clear that the regimes can be entirely different. If regime means outcome rather than process, then you can have entirely different regimes within a single collective agreement. You could have part one that deals with, for example, people who work in offices and museums. Part two, an entirely different structure dealing with the different needs of people who work in schools to school terms. But even though the regimes are kept separate within a collective agreement, comparability is permitted. But even outside that example, on Asda's case, the North hypothetical will allow comparisons between entirely separate regimes if the comparator's regime is formed by a collective agreement that is expressed to apply to all of our factory workers rather than all of our workers in our factories. And so it is the application, known application of Section 1.6 is not consistent with the test being separate regimes. The purpose of Section 1.6 taken as a whole is to extend comparability beyond single establishments. That's why it's there. And the purpose of the common terms test is to prevent that extension to cases where the disparity results from geography or similar and not sex discrimination. In other words, it prohibits comparisons that are not apt or appropriate to identify sex discrimination. It is not intended to prohibit comparisons that are appropriate to identify sex discrimination, subject, of course, to the employer's opportunity to establish a defence. Now, I'm going to move to the British Coal case, and the relevant part of the judgment, this is Lord Slynn for the Appellate Committee, is at page MS 477. And there are a few passages here that I rely upon. The first, between B and C, Lord Slynn says, common terms and conditions of employment must be observed either generally, i.e. for all or perhaps for most workers, or for employees of the relevant classes. And I refer to the part in parenthesis because it would, the test simply wouldn't work if it had to be everyone. It's enough for it to be most people for the generally test to be satisfied, and I'll come back to that later. But at the bottom of this page, at H, the issue is identified, and in summary, the employer said that there had to be, for there to be common terms between the comparator class, there had to be uniformity, and that was rejected by the claimants, who argued it was enough if there was broad similarity. And that one sees at H, one sees the claimant's case at H. And Lord Slynn goes on to say this, your lordships have been referred to a number of dictionary definitions of common, but I do not think that they help. The real question is what the legislation was seeking to achieve. Was it seeking to exclude a woman's claim unless subject to de minimis exceptions? There was complete identity of terms and conditions from the comparator at his establishment and those which applied or would apply to a similar male worker at her establishment. Or was the legislation seeking to establish that the terms and conditions of the relevant class were sufficiently similar for a fair comparison to be made, subject always to the employer's right to establish a material difference defence under section 1.3 of the Act. And dropping down to C, Lord Slynn makes clear that he thinks it's the second of those purposes, i.e. to ensure that a fair comparison can be made. And he rejects the notion that identity, complete identity, can have been intended. And what he says at C is the purpose of requiring common terms and conditions was to avoid it being said simply, a gardener does work of equal value to mine, and my comparator at another establishment is a gardener. It was necessary for the applicant to go further and to show that gardeners at other establishments and at her establishment were or would be employed on broadly similar terms. It was necessary, but it was also sufficient. And so, all of that, I say, is it establishes what the purpose is, and also it establishes what one of the two tests can be, which is the broad similarity test, as an alternative to showing a single collective agreement or other similar genesis. Now, here, the broad similarity test was applied in particular in relation to the bonus and the coal allowances, because the complaint in this case was that the male comparators received a bonus and they received a coal allowance, and the women did not. And here, there was no collective agreement that provided for the amount of bonus or coal allowance that would be provided to a surface mine worker theoretically working at one of the non-colliery establishments. And the reason for that is that the bonus and the coal allowance was always set at the particular colliery. And there could be significant differences. I think at one colliery you'd get 6 tonnes of coal a year, at another you'd get 10.5 tonnes of coal. But it all depended upon exactly which colliery you were at. But that wasn't an obstacle to comparability here, because the differences all fell within the broad comparison test. And one sees that at 479, between E and F. E and F is the tribunal's decision. And in the last sentence, they've said that they set out to make the broad comparison. That's taking language from Leverton. And that was understood by Lord Slynn in the sense set out between F and G. He says, the tribunal was not therefore looking for identical terms and conditions other than de minimis differences. It was, as I read it, directing itself according to the test which I have indicated that I consider to be the right one, namely that a broad comparison should be made, as Lord Bridge of Harwich indicated. And then dropping down at G, in any event, it seems to me that when dealing with the comparison of terms and conditions, the relevant classes have been established. The tribunal clearly adopted a broad common sense approach, which seems to me to have been in accordance with the speech of Lord Bridge of Harwich. And the Appellate Committee suggested that or found that the Employment Tribunal was entitled to take the view on that basis that there was a broad similarity between the terms and conditions of the surface mine workers wherever they worked. And there is, importantly, there is no suggestion that there was any existing collective agreement that dealt with the amount of coal or the amount of bonus that a notional comparator working at one of the office would have received. And instead, the approach that was taken is that the variations in the calculation were matters of detail that did not undermine the broad similarity. And one sees that most clearly at 481 between B and C, where Lord Slynn says, this is the second sentence, true, the amount varied in accordance with the pre-existing local agreements, as was accepted in the national agreement. The essential term was, however, that all these surface mine workers should receive concessionary coal or concessionary fuel. Goes on At D, if, as I consider, the terms and conditions do not have to be identical, but on a broad basis to be substantially comparable, then it seems to me that the Industrial Tribunal did not err in law in the way it directed itself, and that there was clearly material on which it could base its finding that the claimants and their comparators were in the same employment. Now, that's all I want to say about British Coal. I do want to look at North again, and that begins at 538, but paragraph 34, which I referred to earlier but didn't go to, is at page MS 549. And this paragraph, which is the third of the reasons Lady Hale gives for allowing the appeal, I say is key. And she says, in the third place, to adopt such a test would be to defeat the object of the exercise. That's a test requiring it to be possible for the comparator, the notional comparator, the North hypothetical, to work at the claimant's establishment. And she says this is not just a matter of preventing employers from so organising their workplaces that the women work in one place and the men work in another. There may be perfectly good reasons for organising the work into different places, but the object of the legislation is to secure equality of treatment, not only for the same work, but also for work rated as equivalent or assessed by the experts to be of equal value. It stands to reason, therefore, that some very different jobs, which are not or cannot be carried out in the same workplace, may nevertheless be rated as equivalent or assessed as having equal value. One example is the female office worker who needs office equipment in a clean environment, and the male factory worker who needs machines which create dirt and dust. Another is the female factory worker who puts microscopic circuits on silicon chips in one factory, and the male factory worker who assembles computer parts in another. The fact that of necessity their work has to be carried out in different places is no barrier to equalising the terms on which it is done. It is well known that those jobs which require physical strength have traditionally been better rewarded than those jobs which require dexterity. It is one of the objects of the equality legislation to iron out those traditional inequalities of reward where the work involved is of genuinely equal value. And that is, I say, the one of the key points in this decision, which is to permit comparisons between very different workplaces. Paragraph 35, between F and G, does say, I think my lords, my lady, were taken to this yesterday, the same employment test at F, same employment test should not be used as a proxy for those tests, i.e. the material factor test or the work of equal value tests, as a way of avoiding the difficult and complex issues which they raise, tempting though this may be for large employers faced with multiple claims such as these. Its function is to establish the terms and conditions with which the comparison is to be made. The object is simply to weed out those cases in which geography plays a significant part in determining what those terms and conditions are. Now, one of the final passage I'll refer to is in the conclusion, paragraph 41, page 551, when there is paragraph 41 starts with a discussion about Robertson and single source. But the last sentence, I say, is important. However, for the reasons given earlier, the section 16 test sets a low threshold which does not operate as a barrier to the comparison proposed in this case. And the role of section 1.6 as a low threshold condition is one that is to be taken into account in deciding exactly how much evidence is required in the hypothetical exercise. Now, what is not found in this or any of the earlier cases is a detailed analysis as to the scope of the collective agreement, the Green Book, on its proper construction. None of the cases look to see if the collective agreement refers to all of our swimming pool attendants or all of our attendants working at our swimming pools. And nor does it examine whether a swimming pool attendant, as defined by the collective agreement, is someone who is working at a swimming pool. Now, if the North hypothetical turned to any significant extent on the terms of existing collective agreements, in my submission, that would have been done and would have been mentioned. But it is, in my submission, very unlikely that matters of construction of existing collective agreements are intended to provide the basis for permitting or prohibiting comparisons. First, that's because the court was anticipating situations where comparators would not, in practice, ever actually work at the claimant's establishment. And so it's very unlikely that comparability would turn upon whether an existing collective agreement covered a situation that was never going to arise in practice. It would be random, no rational link to the purpose of the legislation. But what's more is it would also narrow the scope of equal pay legislation to industries that were heavily unionised. And that in itself would narrow the scope in a way that's not justified by the legislation itself. But it may be that I think it's accepted that it's simply that the North hypothetical requires a hypothetical conclusion that doesn't need to be established in a particular way, and just requires evidence to support it. Now,
so can I just interrupt, make sure I'm following this? So if I'm following, then if, for example, you're carrying out this hypothetical exercise and trying to envisage, for example, a distribution worker employed by Asda being hypothetically assigned to work at a supermarket, you would say that whether the collective agreement applying to distribution workers says explicitly distribution workers working at our depots or not doesn't make any difference, because whether that clause is present in the contract or not, the contract could never have been intended to apply in the context of a supermarket, because it's impossible that a distribution worker would have been working there.
yes.
And so one puts that out of one's mind when carrying out the hypothetical exercise. Is that the argument?
My lord, yes, it is. Because the written case of the appellants put great store by there being an existing collective agreement or similar instrument. And in my submission, that cannot have been the intention of the legislation, because it would depend on drafting style rather than the substance of any agreement or any other instrument. And what matters is that the hypothetical exercise is approached in the right way. And in my submission, it was. But I will deal with that in due course. But first, I will turn to the Employment Tribunal decision itself. And it's at page 300, MS 300, that the tribunal addresses the common terms question. And this is at paragraph 192, where the employment judge says common terms need to be considered in three ways. First, whether there are and were common terms generally, as between claimants and comparators, and I pause between the word generally and as between claimants and comparators, and I'll come back to why. Secondly, whether there were common terms in the alternative for employees of the relevant classes under section 1.6. Pausing there, that is, I say, the first and second of the alternatives identified in the cases. And thirdly, whether there are common terms as between A and B under section 79 of the Employment Act 2010. And that needs some explaining now, but at the time, it was the appellant's case that the change in the legislation in 2010 meant that the claimant did have to show she had common terms with the comparator. And that was held not to have been the effect of the change in language in the 2010 legislation. And that point is no longer being pursued. But it is helpful because it shows that one of the three alternatives that was mooted was a direct comparison between the claimant and the comparator. And that is not the exercise that the Employment Tribunal was considering as its first alternative. The first alternative was, in my submission, simply to see whether there were common terms generally. The words as between claimants and comparators don't identify the legal test, but they identify what the practical exercise would involve, because on the facts of this case, most employees at stores or in depots were on the relevant depot hourly paid terms or retail hourly paid terms. There was a cohort of managers across the two establishments. I think yesterday, my own friend Lord Panic said there were very limited exceptions in stores, and that's true. But most people at the stores and at the depots were on the depot hourly paid terms or the retail hourly paid terms. And so if those terms were broadly similar, then it would broadly similar in a way that was sufficient to meet the test in Smith. It would follow that common terms were observed generally. My
There's
Lord,
a
Lord
question
Legate.
for you.
Yes.
I can see, Mr. Short, how broad similarity works when you're focusing on the comparators amongst themselves. And it's not important, really, whether some people get a coal allowance of 10 tonnes and some get an allowance of 6 tonnes, when what you want to complain about is the fact that they all get a coal allowance and you don't. But I can't see how it coherently works when you're not focusing on the comparators, but you're looking at the whole collective, because it seems incoherent to be saying, on the one hand, there are no relevant differences amongst the generality of people, amongst the common, so that there are common terms, but on the other hand, there are relevant differences because I'm alleging discrimination.
Yes. Well, my Lord, in my submission, the answer there is the word relevant differences. And I go back to the example I gave earlier of two separate, but not geographically very different establishments, where the terms and conditions in relation to pay, holiday notice, everything else are the same, but bonuses are only paid at the male establishment. Now, in those circumstances, establishing a similarity, a broad similarity between general terms, is sufficient to enable a fair comparison to be made to see whether the differences derive from sex discrimination.
But why does the degree of similarity or difference between the non-discriminatory terms make it fair or otherwise to judge whether there's discrimination? And how do you tell how similar is similar?
Well, how similar is broadly similar, so that's a question of fact. But the reason why it's helpful is twofold. First of all, as I've said, it allows one to focus on the differences to decide if that is a result of sex discrimination in a way that would be difficult, much more difficult, if the entire shape of the two packages was very different. So if you were comparing hourly paid staff in one area with people who were entirely paid by commission in another on a 0 hours contract, so the comparison would become very difficult as a result of the differences. But here, if the shape of the packages is broadly similar, that is enough, partly because it allows a comparison to be made, but also because it defeats the notion, insofar as it's relevant, but it defeats the notion that you have two entirely separate regimes. Because if you have two sets of packages that look similar, save for the elements that are said to be discriminatory, you can set aside the notion that these are entirely separate, unrelated regimes and just focus upon whether there's a good reason for the differences. But my Lord, that point is the point made by the appellants when they criticise the factual exercise that was carried out by the Employment Tribunal in identifying whether there was or wasn't similarity. But my Lord, that's the position. My Lord, Lord Hodge.
Following up on Lord Legate's comment, in paragraph 192 to which you are referring us, it talks about common terms generally as between claimants and comparators, and you say you're looking at claimants and comparators. But I wonder if it would be more consistent with the prior case law if you're looking for common terms generally as between claimants and common terms generally as between comparators. And I refer in this regard, if I may take you to MS 477, a passage in the British Coal Corporation to which we weren't referred, which is page 526 at letter E to G, where Lord Slynn says that it is accepted by the corporation that for the purposes of this appeal, as between the different establishments, common terms and conditions do in any event apply to the two classes of claimants. What therefore has to be shown is that the male comparators at other establishments and at her establishment share common terms and conditions. If there are no such men at the claimant's place of work, then it has to be shown that like terms and conditions would apply if men were to be employed there and a particular job's concerned, i.e. the North hypothetical.
Absolutely.
So what they seem to be doing, the court seems to be doing, is setting up on the one hand common terms as between the complainants, and on the other common terms as between the comparators. What it doesn't seem to be doing is saying we need common terms between the complainants and the comparators, as Lord Legate says. And I'd be grateful for your comment on that.
My Lord, I say that comparison is the comparison between the relevant classes. And that is the second of the comparisons carried out by the Employment Tribunal in this case. And going back to 192 at page 146, we see paragraph 192 that the three alternative comparisons that were being carried out. The first, common terms generally. The second, in the alternative, for employees of the relevant classes. And that second comparison is exactly the comparison that Lord Slynn was engaged in.
Yes, the first one, I'm sorry to interrupt, the first one is, I mean, as Lord Justice Underhill made it clear, you're going down the wrong alley. That's the type of comparison that was rejected in Leverton.
Well, my Lord, what I say about that is that the words as between claimants and comparators were unfortunate because they can mislead. They can give the impression that that was the comparison that was being carried out for its own sake. But the important word in this sentence, I say, is generally, because it was common terms generally that were being carried out. And as a matter of fact, most of those employed at the relevant establishments were either on the claimant terms or comparator terms. And that is why, if there had been common terms generally between those individuals, you would have established common terms for all or most people at the establishments, and that would be sufficient. Not because the claimant and comparators terms had to be similar, nor because it was sufficient in itself to show that similarity, but because where the bulk of the workforce at the relevant establishments was on one set or the other, a finding of commonality between the two packages was enough to show the first type of commonality.
Well, it seems to me at the moment that the point that was made to you by Lord Legate a few minutes ago was substantially the point that Lord Bridge made in Leverton when he spoke about the sort of will-o'-the-wisp search for an undefined substratum of commonality, yes, in what are ex hypothesi alleged to be discriminatory differences between terms and conditions.
Yes. But my lord, what I say to that is Lord Bridge was concerned with ensuring that that claimants weren't required to show they had similar terms. He wasn't dealing with a situation where they were able to show that that similarity meant that everyone, all or most people, had the same terms. But my lords, my lady, I think I've made that submission. I was going to try and leave it, but then I'm asked a question about it by Lord Leggatt.
I just wanted to put up an example to you. Suppose that your complaint is about pay differentials, but in fact, the only pay differences are regional, and that people in London get paid more than people in Newcastle. If you were looking at differences between the two classes, then that claim would get weeded out on a geographical basis. But if you look at the terms generally, maybe they're all on similar terms, except pay, which you ignore because that's what you're complaining about. And then you're in the door on that claim and there's no weeding out at all. Is that how you say it operates?
Well, I think one needs to look at the particular applications in the context of the differences that are found. In that case, in your lordship's case, it would be the case that it's a geographic difference. It's not apt to identify sex discrimination. But against the factual background here, where we know it's not regional, we know that wherever the men work and wherever the women work, the male-dominated job is paid more. I say that is sufficient to get one's foot through the door. But as I was about to leave this point in any event and move on to the North hypothetical, which is the second part of the...
I'm sorry, before you move on to the North hypothetical, I mean, how important to your case is the point that you're making? Because I mean, if the comparison, as Lady Hill said in paragraph 35 in North, if the same employment test is there to establish the terms and conditions with which the comparison is to be made, and you're weeding out geographical differences, then what you're looking for is commonality across the country between the comparators, wherever they may be. One is not looking across from the claimant's terms to the comparator's terms at all. So can you tell me, I mean, if that were right, would that have any effect, adverse or favourable to your case?
Well, what Lady Hale was considering was the second of the possible comparisons, which is within the relevant classes. She was not dealing with the question of when common terms were observed generally. And so it doesn't affect that part of my case. And I say I only need to succeed on one of these matters. The tribunal's factual findings, though, that there was, save in relation to the disputed terms, a broad similarity, is relevant also to the relevant classes comparison. And I'll come back to that in due course when I deal with the relevant classes comparison, which I'm hoping to get to now.
Before you do, Mr. Short, and we are waiting with anticipation for this. I'm just wondering if you're turning now to a new topic. Might this be a convenient moment for us to have a short adjournment?
My lord, it would be. I had wondered about whether suggesting that, but I thought that might look cowardly. So in the circumstances, so I decided not to do that. But my lord, yes, it would be a very appropriate moment, and I will deal with the North hypothetical when we come back.
Well, very well. Well, thank you very much. Well, in that case, we'll simply turn off our video and audio feeds for 5 minutes, and then we'll resume.
I'm grateful.
Yes, I think we're now ready to resume, Mr. Short.
My Lord, I'm grateful. I was about to turn to the North hypothetical, which is dealt with by the Employment Tribunal at paragraph 218 onwards, at page 303, MS 303. And there is a lengthy factual analysis carried out by the Employment Tribunal between paragraph 218 and paragraph 242, when the Employment Tribunal explains its reasoning and why it found that using the North hypothetical, there was or would have been common terms as between members of the relevant comparator class. And in my submission, that is a question of fact, that it was open, or a question of fact that the tribunal was required to answer, and it has answered it in an acceptable way. As I understand the appellant's submissions, it's no longer suggested that the question of fact has to be answered by reference to an existing collective agreement or other instrument. It's simply something for the tribunal to address. This is something that was dealt with by the Court of Appeal. And if I can ask my lords, my lady, to look at page 177, MS 177, we have at paragraph 63 onwards, Lord Justice Underhill's review of the relevant law. And the material proposition is his fifth point at paragraph 70. And it says, it will be straightforward to answer the North hypothetical question in the claimant's favour if there is a collective agreement governing the terms of the two classes without reference to where they work. That is so whether it's a single agreement which covers both classes, as in Leverton, or separate agreements for each class, see per Lady Howe in North. But although that is the paradigm case, it is not the only basis on which it may be possible to find that common terms and conditions apply, or more particularly that the North hypothetical is satisfied. It would equally be the case, for example, if the employer imposed terms on an across-the-board basis, or simply if it could be seen as a matter of fact, employees in the relevant classes enjoyed the same terms and conditions wherever they were employed. And that last sentence is a posit here, because wherever the depot workers work, they are on depot terms and conditions. And the fact that depot workers only work in depots doesn't change that. The appellants say there was no evidence to support the conclusion, and as a perversity test, they really need to make that good in order to succeed on the facts. And I say that's wrong, and I'll go to the evidence shortly. But before I do that, I make some general points. The first is there cannot be too onerous an evidential requirement here. Lady Hale made clear that section 1.6 was intended to provide a low threshold. And what's more, evidence is being sought in relation to what would happen in an entirely unrealistic set of circumstances. That's why the North hypothetical is being engaged. And given the purpose of the hypothetical, in my submission, one should assume that there would be a transfer on the same terms unless there was good reason to think otherwise. So if there was a transfer from London to Newcastle and it was clear that all the workers at the London establishment were paid £10 an hour and all of the workers in Newcastle were paid £9 an hour, then one would doubtless assume that upon a transfer from London to Newcastle, the hourly rate would change. But that is only where there is a good reason to think that's the case. It certainly wouldn't be enough for the employer to say, well, we always pay those in male-dominated workplaces more than those in female-dominated workplaces, so that if a comparator moved to a female-dominated workplace, his pay would be reduced, because that would frustrate the purpose of the hypothetical and frustrate the purpose of the act. But in any event, that wasn't the position here. And I'll deal with the question of rates of pay and how they fit in to terms and conditions generally. The position as it was, as I understood, of the appellant submissions before the Employment Tribunal was this, that terms and conditions applied to everything. That was the entire package. And pay was simply one element of that. And even if pay wouldn't have changed in a move from a depot to a store, they said the other terms and conditions would have changed. And that was the evidence, certainly the evidence of Ms. Tatum, and that explains why there are references to the pay not changing, but terms and conditions going with the site at which the person in question worked. Now, I say that I understood that to be the case. In the supplementary bundle, the second bundle at page 794, we have the closing submissions from Asda before the Employment Tribunal. And Roman numeral 3 makes this point, expresses this distinction. Cross-examination by the claimant's counsel on this topic was limited to pay rates. It was suggested in questioning that depot pay rates would still apply if someone did his depot job in a nearby store, because Asda would pay the rate for the job. The focus of those questions failed to address the legal test, which is whether someone's entire package of terms would remain fundamentally similar or transfer to a store. Even if pay terms might remain the same, the evidence is that transferring colleague would adopt the general package of terms, including hours, holiday, sick pay, etc., applicable at his or her destination. Now, in relation to pay, yesterday, my learned friend, Lord Panic, went to the transcript of my cross-examination, and there I say it's tolerably clear that Ms. Tatum certainly accepted that the pay went with the job, so that the pay wouldn't change. And the point that was made is that in relation to the comparator, the question I asked was if there was a depot in the car park. Now, I'm not sure I'd accept that that has quite the impact that's suggested, But even if it does, if I could refer to page 37 of the supplementary bundle, which is an extract from re-examination of Ms. Tatum by Lord Faulkner. It really deals with this head on and leaves one in no doubt as to the true position. And at page 81 of the transcript, the internal numbering, he asks a question about what would happen to the terms and conditions of a depot employee moving within a store. The answer is inside a store, terms and conditions are common for everyone in the store, so they would pick up store terms and conditions. The next question and answer explains that. And then at 82, line 3, Lord Faulkner says, in the context of terms and conditions being the store terms and conditions for this hypothetical employee doing distribution work within a store, as far as pay is concerned, what would the position be? And the answer is the work attracts the pay. So if they were conducting depot work hypothetically inside a store, then it's the work that attracts the salary. And then those questions are asked in relation to the a retail employee moving the other way. And again, it's said that she would take the terms and conditions. And then at the bottom of 82, and the position, the questions asked, and the position in relation to pay, answer hypothetical situation, but the work attracts the pay rate. So if they were doing shop work, they would be attracting shop pay. And so that's the end of that argument in my submission. There was clear evidence that on Asda's case, that the pay rate would stay the same. And it's the pay rate that is at the heart of the case. So we know this is not Lord Bridges' example of geography. And to, I think, borrow from the question put to me by my Lord Legate, I ask rhetorically, why differences in relation to probationary period or the amount of notice the employee was required to give should prevent a comparability or prevent comparability in a claim about pay. I think the question I was asked was, why should similarities allow a claim about, allow comparability in a case about pay? But what I say is the same point can be made about such differences as there were, because the important term, pay, what this is all about, would not have changed on that evidence. In any event, those other differences aren't to be taken into account because the employment judge didn't accept that they would change. But what cannot be ignored is his finding and the evidence that pay would have stayed the same. My Lord Lloyd-Jones.
Mr. Short, before we leave this re-examination, what weight do you say we should give to answers given addressing a purely hypothetical situation?
Well, it is always difficult to know exactly how much weight to be given to evidence in that situation, because it is obviously, it is hypothetical, and here it's not just hypothetical, it's a hypothesis that would not happen in practice. And so in those circumstances, that's why I submit that you shouldn't assume that there would be changes likely without good positive evidence. Here, it is speculation, but it is informed speculation from Asda. And I say that partly because it suits my case, and doubtless Asda thought there may be other problems for them further down the line if they said they would have changed pay. But if facts are required, then this is sufficient.
Thank you.
My Lord Legate.
It seems to me, Mr. Short, that by accepting the hypothetical question in this form, by imagining the depot worker in a store, you've already given too much away, because if the nature of somebody's job is inherently tied to the environment in which they work, you can't do the same job if you're moved to a store. So what you ought to be imagining is if the store turns into a depot, is converted into a depot on that site, same geographical location. Or if a depot, to use your other example, is built right next door to the store where the car park was. And still imagining then the person doing the same job as before. Because once you start to picture the depot worker in a store, then it becomes hopelessly confused.
My Lord, I have to accept that. Yes, that's correct. If my original submission that the purpose of this is geography rather than regimes, then that must follow, because it would be the geographical location that allows one to address the concern, but also have a proper analysis of what is likely to happen in circumstances which are at least feasible. So it doesn't need to be feasible that the claimant would be at that establishment, but it is certainly an appropriate way to test whether the terms would change or would remain broadly similar with one eye on the legislative purpose. So if I say either because of the answer to the question in re-examination or because of the answer to the question in cross-examination, actually both bases are covered. And there is evidence that pay would remain the same. One also has the fact of the pattern of pay, I think that's set out in paragraph 4 of our written case, that shows across the whole country the depot workers are paid more than the retail workers. The detail may change, but that is always the case. The highest paid basic retail worker in London is paid less than the lowest paid depot worker in Grangemouth. And so putting those matters together, one can see depot workers are always paid more. That's enough to establish this hypothesis, particularly if it's in a depot and particularly supported by Asda's own evidence. Now, in fact, I was going to move on to the point made by the appellants that the distribution terms only apply in depots, and the suggestion that that in itself defeats the North hypothetical. And we say that that's not the case. In fact, that's what engages the North hypothetical. And the fact that depot workers don't work in stores is the reason that this hypothetical exercise is gone through. The Court of Appeal again deal with this at page 1 MS 187, that's of the core bundle, not the supplementary bundle. and that's at paragraph 102 of Lord Justice Underhill's judgment, and it really deals with a point that's cropped up several times. And he says this: the third point depends on what are said to be the ET's findings that store terms are specific to stores, depot terms are specific to depots. It's said that it necessarily follows that a distribution worker doing distribution work, however unfeasibly, at that store would not enjoy distribution terms. I do not accept that. On one view, saying depot terms are specific to depots is saying no more than that distribution workers only work at depots, which is precisely why the North hypothetical comes into play in the first place. It doesn't help to answer it. However, if what is meant is that at least some aspects of distribution terms reflect the specific characteristics of distribution work, that is not inconsistent with the proposition that distribution terms apply to distribution workers wherever they are employed. The hypothesis is, of course, however unrealistically, even if working in a store, the worker in question will be continuing to do distribution work. So this is the analysis, and the fact that the terms in practice have been linked or have been provided only at depots doesn't answer the hypothetical. My final point on this is to go back to the Employment Tribunal's decision at MS 118. No, I'm sorry, that's a bad reference. To go back to paragraph 99 of the Tribunal's decision, which I'll find in a moment.
It's on page 272.
Oh, I'm very grateful, my lord. Yes. And in fact, it's from paragraph 88, in fact, page 270, where the tribunal goes through the exercise of comparing the two packages of terms. And even if that wasn't appropriate in relation to establishing common terms generally, it is useful in deciding whether there would be common terms on a move from a depot to a store. Because on the tribunal's analysis, many of the terms are identical. Things like mobility clauses, share saves, pension rights, notice rights, or have very minor differences. Things like notice required from the employee. And even when the differences were more significant, they were still modest and not enough to break the broad similarity taken as a whole. The main differences were pay, and on the earlier finding of fact, on the evidence, pay wouldn't have changed. And so on those, as a result of this analysis, it would follow that even if someone, a depot worker, had moved to the retail terms and conditions, that didn't make very much difference in relation to all of these terms and conditions. The only important one is pay, and that is staying the same. Now, we say that doesn't arise anyway, because the Employment Tribunal held that the terms and conditions wouldn't change. But even if they had changed, the changes weren't particularly material, they weren't very substantial, and the decision that the North hypothetical is made out with common terms is one the tribunal is entirely entitled to reach on the facts and cannot be impeached at this stage. Now, one point was made in relation to the position before 2012. And prior to the appeal to this court, the case has always been put on the basis that there are two regimes and two sets of terms, depot terms and store terms. There were differences between each depot, much as there were between the different collieries in Smith, but it was not suggested that those terms or those differences were so significant that they were the terms were not to be treated as being broadly similar across the board. Now, this was raised expressly but by the court, by Lord Justice Underhill, in the Court of Appeal. And this appears at page 180, at paragraph 82, where he says, I should note one point recorded by the employment judge, which removed a different potential issue. As noted in paragraph 9 above, there were some variations between the rates of pay at particular depots. Paragraph 88 of the reasons reads, it was not suggested that comparators who work in a particular distribution centre had variations between themselves, although the respondent's case is that terms for pay could vary from depot to depot. And so that's not perhaps very clear. Mr. Short explained without demur from Mr. Jeans that Lord Falconer had expressly been asked in the ET whether Asda was arguing that different regimes applied at different depots and had confirmed that it was not. The concession is not surprising, given that all that is required is broad commonality of terms and the existence of minor variations between establishments, as in Smith, is immaterial. Now, not only did I say that without demur from Mr. Jeans, but we provided the Court of Appeal and Mr. Jeans with the relevant extract from the transcript, and this appears in the supplementary bundle at page 39.
I'm sorry, just before we go there, when you were taking us through the ET decision, I just noticed it's not perhaps, well, it's perhaps of some materiality. At page 275, I just wonder if we ought to be having regard to this. Paragraphs 111, 112. Now, this isn't a hypothetical of distribution employees deployed to stores and doing distribution work. It's evidence of real life deployment of distribution employees to stores to do retail work. And what we see at the end of 111 is that they were continuing to be paid their distribution rates of pay although they were working in stores.
Yes. And, my lord, I think that evidence is referred to again by the Employment Tribunal in its decision or in its reasoning.
Yes, I mean, it's not the hypothetical because they weren't doing distribution work, but it's sort of a fortiori of the,
yes.
of the hypothetical.
And it's at page, paragraph 240 at page 306. It's paragraph 240, and the employment judge considered that it provided some slight support for our case. So that's a very measured approach in my submission. He doesn't say it governs the case. Obviously, there are differences, but it gives some slight approach. He then deals with my suggestion of a depot in a car park.
Yes, well, yes, but one can have regard to it in assessing the evidence of misstatement, for example, that anyone working in a store would automatically go on to store rates for the sake of fairness with the other store employees. And one sees that isn't what actually happened when distribution workers were deployed into stores.
Well, my lord, Ms. Tatum's evidence was that it would depend on the work that they did, not just because they went into the store. So I think her evidence very clearly was if they continued to do depot work in the store, they would continue to get depot pay.
Yeah.
And this is a slightly different point, but this is a factual matter that the Employment Tribunal dealt with properly and was entitled to rely on and reach a decision that's been considered on several occasions, hasn't been impeached on the grounds that it was perverse or otherwise not supported by evidence. And my lord, I think I'd gone to the supplementary bundle at page 39. And here, starting at page 41, Judge Ryan referred to uniformity of terms between cashiers, whether they're in Land's End or John O'Groats. Lord Faulkner says, in any store, that's correct. That's absolutely right. Question for me is whether pre the National Recognition Agreement, the same can be said for the distribution operatives. Lord Faulkner says yes. He goes on to explain, and he says, Judge Ryan asks, this is at 16, do you say there are effectively broadly comparable terms negotiated by the GMB for the different warehouse operatives in the different depots that come within the NRA appendix subject to local variations? Lord Faulkner says yes. I mean, I'm not really disputing that within distribution there is an employment regime that applies across the board in distribution. Pausing there, that's a general comment. That's not limited to post-NRA. And that's made clear further down at 5 of page 42. Judge Ryan says, your case is, yes, there is a broad regime within distribution and a broad regime within retail, which may be highly material if I'm in North hypothetical, pre or post the Equality Act. Lord Faulkner says, yes. Judge Ryan says, are you putting the case this way? And Lord Faulkner says, no, I'm putting my case like this. I'm saying there is a broad retail regime. I'm not taking any sort of British Coal Corporation versus Smith point insofar as I am relying on any differences within retail or within distribution. because what the coal board were arguing is that concessionary coal arrangements meant there wasn't even broad similarity, that they were trying to increase the difference that was required. I'm making a much more basic point. You've got your distribution terms. If you work in a depot, they are geographically related, and when you leave that depot, they don't travel with you. Now, that's the point that was made, that they don't travel. It was not suggested that differences in the pay rates pre or post the Equality Act, which is 2010, so before the National Recognition Agreement, but it was not suggested that differences in pay rates or other minor differences between Wigan and Skelmersdale meant that there was not a single broadly comparable set of terms across distribution. We have in the bundle 150 pages of Asda's written submissions, and each side made 2 days of oral submissions across the hearing, all of which were transcribed, and there isn't a single submission recorded where it said Skelmersdale paid X, Wigan paid Y, and therefore it's outside the broad range of similarity. It's always put in the same way. There are distribution terms and retail terms, and it's too late. This wasn't a ground of appeal to the EAT, wasn't a ground of appeal to the Court of Appeal, and it's too late now to invite a factual inquiry of that nature to see if the differences went beyond broad similarity. My Lord, my Lady, they are the submissions I wanted to make in relation to the North hypothetical. And so, unless I can assist further on that, I am going to move on to EU law. Now, as an overview, I say there are 4 points. The first is that single source is a standalone gateway to comparability under EU law. That was the view taken in the DEFRA, Robertson case in North, and by the courts below in this case. And as I understood it, the contrary position wasn't developed. I can see that my learned friend Lord Panic may be able to assist.
Not to assist, but just to inform the court that I'm told that the public broadcasting system is not working. So, yeah, so my solicitors, and I assume Mr. Short's instruction solicitors can't watch this at the moment.
Right.
I think that's a general problem. That's what I'm told. Our information may or may not be correct, and it may or may not matter, but I draw it to the court's attention.
No, it matters to us, and it also, I would think, matters to those instructing you both. We'd better wait until we've got this clarified and sorted out.
Might it be better, my lord, to adjourn for lunch early and start at 1:25, or does your lordship want to deal with it now?
Well, shall we adjourn? Shall we adjourn for in 5 minutes? I think I should be able to find out what's happening. So shall we adjourn for 5 minutes just now?
My lord, I'm told it's working again now, although it wasn't working for 10 minutes.
Is that right? Yes, we can confirm that. It is now working again.
Oh, fine.
Thank you. I apologise, but I thought it right to draw attention to it.
No, I'm very grateful, Lord Pennick. I should Yes, I've had a message from our IT engineer confirming that live stream is now working.
Thank you very much. Thank you.
So, well, I can only apologise for the fact that we seem to have had an interruption in the live stream service there, but we better now resume the hearing.
My Lord, I'm grateful. As I'd say, I from the oral arguments that were put yesterday, I didn't understand it to be maintained that single source is not a standalone gateway to comparability, and that if there is a single source, then that is enough to bring one within Article 157. We've made detailed submissions on that point in our written case, but if I'm correct in thinking that's no longer a live point, I won't deal with them now. The second point is that in my submission, Asda is the single source in this case. Distribution and retail are both parts of Asda, and Asda does not cease to be a single source by delegating responsibility to different managers internally. As a result, the Employment Tribunal is entitled to reach the view that it took. Thirdly, I say that the legislation can readily be construed to allow this outcome, or to allow a comparison that's permissible under EU law. And fourthly, and finally, on the question of direct effect, this is only relevant if the claimants are entitled to make the comparison under EU law. So if they're successful on points 1 and 2, but it's not possible to construe the legislation consistently with that. So I say that it doesn't arise, but in any event, I won't make detailed submissions on the substance of direct effect because there's seems to be little point, bearing in mind the Court of Justice will soon give us a decision. I may say a couple of things, but there we are. So I'm going to move to the second of those points, and the question of whether Asda was a single source. But I'll do that in the first instance by reference to the Lawrence decision, because it does shed some light, and that's at page 641 of the core bundle, MS 641. And the opinion of Advocate General Gielhud begins at 642, but the key paragraphs, I say, are paragraphs 36 and 37. That's, or they start at 36 and 37. That's page 649. And at 36, he records the arguments of the United Kingdom government and Mighty, the respondent. And I say this is helpful because it's plain that he adopts them in his conclusions, and they do shed some light upon the proper approach to single source. And at G, it says in 36, United Kingdom government and Mighty also do not exclude a comparison with employees working for other employers as such, but take a view there must be a common source from which the terms or conditions of employment at issue in the specific case can be derived, such as is the position where different employers are required to apply the same collective bargaining agreement in the case of a group undertaking, or authorities under common control, where those terms and conditions have been laid down by statute or regulation. And then at 37, at B, they explain why there's necessary for there to be a single or common source. And it says, where the pay terms of different employers cannot be traced to a single source, the United Kingdom government submits pay discrimination on the grounds of sex cannot be confirmed on the basis of a purely legal analysis. By way of illustration, it presents the situation in which one employer provides a higher rate of pay than another employer. Employees of the second employer cannot derive from that fact any entitlement to the same rate of pay as that provided by the first employer, even if the second employer happens to have a predominantly female workforce. That fact by itself is not sufficient ground to justify the conclusion that there is pay discrimination based on sex. The only conclusion possible in such a situation is that there are differences in the terms of remuneration of two employers. Pausing there, of course, that's not the position where you have one employer that decides, even through different structures, to pay people differently. And the second problem is at 38. The second problem that has been alluded to is that an employer who is accused of pay discrimination on the basis of sex, on the ground that he pays his workers a lower rate than that received by comparators working for another employer, is not in a position to explain that difference or explain why the difference in pay is objectively justified. For that reason also, the Commission, MITI and the United Kingdom government take the view that a difference in remuneration must be traceable to one source alone. And of course, that isn't a problem here, because Asda is in a position to explain why it pays men and women, or the male groups and the female groups, differently, and it is in a position to advance any material factor defence it wishes to do. At 52, this is where the Advocate General sets out his conclusions. He says, Advocates General Cosmas and Lenz, and that refers back to a case called, I think, Gebiet's Krankenkasse is Advocate General Cosmas, and Enderby for Advocate General Lenz. But the Advocate Generals and now the United Kingdom government were right to stress that as an essential criterion, that's traceable back to a common source. Why? Article 141 EC is addressed to those who may be held responsible for the unauthorised differences in terms and conditions of employment. In the cases mentioned, they are the legislature, the parties to a collective work agreement, and the management of a corporate group. They may be held accountable in this regard. On the other hand, if differences in pay arises between undertakings or establishments in which the respective employers are separately responsible for the terms and conditions of employment within their own undertaking or establishment, they cannot possibly be held individually accountable for any differences in the terms and conditions of employment between those undertakings. And then at 54, it's clear from the foregoing that the direct effect of Article 141 extends to employees working for the same legal person or group of legal persons, or for public authorities operating under joint control, as well as cases in which, for the purposes of job classification and remuneration, binding collective agreement or statutory regulation applies. In all those cases, the terms and conditions of employment can be traced back to a common source. And in paragraph 52, I do place particular weight on the expressions being held responsible and being held accountable, because that is the nature of the responsibility that the single source doctrine has in mind, rather than the causative responsibility of having individually and personally set those terms and conditions. Now, the Advocate General's approach was adopted by the court in Lawrence, and we've been taken already to paragraph 18, where that conclusion is adopted, albeit set out in the negative, given the facts of the case. But I'd like to refer also to paragraph 12 of the judgment for one general point. This is at page 657. And at paragraph 12, the court says, as the court held in De Frenner and Sabina, that principle, which is a particular expression of the general principle of equality, which prohibits comparable situations from being treated differently unless the difference is objectively justified, forms part of the foundations of the community. And so the principle of equal pay, which is at stake here, is a foundational principle of law from the community, and its importance cannot be overstated. And in those circumstances, I think it makes it quite unlikely that it is to be limited within a company, a large employer, a state employer, simply because that employer chooses to arrange its internal affairs in a particular way. Now, the single source was treated as providing a standalone gateway to comparability in the Defra and Robertson cases. But
just before we go to those, I mean, while we're here, I mean, I appreciate we're going to get a ruling from the Court of Justice, but one can see paragraph 13, the court has recognised the direct effect of the principle of equal pay. And if one reads back to paragraph 11, you see how the principle is expressed. The principle that equal work or work of equal value must be remunerated in the same way.
yes,
I suppose there might be a difference between equal pay and pay of work of equal value.
but my lady, as I understand it, that is the argument, and that work of equal value, unlike the other forms of equal work, do not have direct effect. There is a decision called Warringham that says the contrary, says it does. I understand the argument is that, well, it wasn't necessarily an issue in that case, but it's absolutely clear on the face of Warringham that the ECJ said it does have direct effect in the cases of equal value. But again, we needn't have that argument now in the light of the yesterday's events. And we're going on to the DEFRA cases. I think it's helpful to start in the EAT, because some of the some parts of the judgment of the EAT are adopted in the Court of Appeal, and the judgment starts at MS 486. And at 492, from paragraph 10, which is at H. This is Mr. Justice Burton. sets out the legislative history of the new employment structure. And he sets it out in some detail over the next 3 pages, and then down paragraph 11, which finishes on 496, which is what established that the various departments had statutory responsibility for negotiating their terms and conditions. And when Lord Justice Underhill said this case depended on its particular facts, I think my learned friend Lord Panic said rhetorically, well, what facts? And my answer is these ones, which are set out in so much detail and which are fundamental to the decision and analysis in these cases. Paragraph 18, which is at MS page 501, Mr. Justice Burton goes on to refer to the Lawrence case, and that makes the point that the fact of common employment isn't sufficient, but he says picking it up at C, it is clear to us that what the Court of Justice is setting out is a justification, principled basis for difference, principled basis upon which responsibility for difference and discrimination can be pinned. This basis is that the differences identified in the pay conditions of workers performing equal work or work of equal value can be attributed to a single source, and that there is a body which is responsible for the inequality and which could restore equal treatment. He then says, this is almost invariably the case where there is a common employer. The best example of such a single source of such a body is a common employer, but the justification can be found not in the common employment, but in the single source. And if there is not such a single source, no such body, then common employment is not sufficient. But the statement that the best example of a single source is a common employer cannot stand against the suggestion that if that common employer internally allocates responsibility to different structures, it ceases to be a common employer. And then again at paragraph 21, effectively the same points made. The Advocate General, having dealt with paragraph 54 of the Advocate General's opinion in Lawrence, it says, of course, it is, as is normal, the much more streamlined judgment of the course of justice which bind us. It appears to us that the court is in fact following and adopting the reasoning of the Advocate General and applying it in more concise terms to the particular problem before it, making it entirely plain that the first matter which distinguished the present case from others was that the persons whose pay is being compared work for different employers. We conclude that Lawrence is not authority for the proposition that common employment is sufficient. It is rather authority for the proposition that what underlines the applicability of Article 141 is that which is ordinarily exemplified by common employment, namely the existence of a common source, the existence of a central responsibility for terms and conditions. If that is absent, then comparability is not available. But common employment ordinarily exemplifies a single source. and that is flatly inconsistent with the approach taken by the appellants in this case. The Court of Appeal adopted that analysis, and the decision is which begins at page MS 525, but it's 532 that I want to refer to. Paragraph 22 says this: it is true that in a typical equal pay case, the comparison is made between men and women working for the same employer, who is normally responsible for levels of pay in the workforce and for discriminatory differences in pay between the sexes, which the employer is in a position to correct. So again, ordinarily, a single employer will be a common source, a single source. And then at paragraph 28, I think the court was taken to this yesterday. He then, Lord Justice Mummery, analyses the Lawrence decision, but then at the end of this section, he says, I agree with the appeal tribunal, paragraph 21, that, and then sets out in full over the next page the passage I've just referred to, and that Lawrence is rather authority for the proposition that what underlines the applicability of Article 141 is that which is ordinarily exemplified by common employment. Paragraph 29 goes along the same lines, and then taking it from C, I agree with the appeal tribunal at paragraph 18 that the Court of Justice was setting out a justification in the form of a principal basis upon which responsibility for difference and discrimination can be pinned. Justification is in the single source rather than common employment. Court of Justice made it clear it's not necessarily the person with whom the workers have contracts of employment that determines the comparability. The relevant body is the one which is responsible for the inequality and which could restore equal treatment. The body responsible for the state of affairs will often be the same employer of both applicants and the comparators, but that's not necessarily so. The last point I want to refer to here is at page 535, and a couple of references were made to this yesterday. And this is where Lord Justice Mummery registers a note of caution about using domestic constitutional arrangements or principles of English public law in the context of interpreting an article in the EC Treaty. And I make 2 points. First, he was, as is clear from the opening words of paragraph 38, he was referring to the 2 points that were being made at paragraph 37, namely that the delegation to government departments hadn't divested the Crown of the power to regulate pay, and that the Crown had the power to revoke the delegation of powers to the departments. So it's made in a very specific context. But perhaps more importantly, goes on to say this: regular students of the jurisprudence of the Court of Justice are aware of the obvious need to be realistic rather than legalistic, and to think in terms of European community law and its specific objectives rather than in terms of English law. And the specific objectives of Article 157 include, predominantly, to eliminate sex discrimination in pay. And the narrow approach urged upon you, in which an employer can cease to be responsible and cease to be subject to equal pay law by choosing to delegate internally to different managers, is utterly at odds with the objectives of Article 151.
This must be a very far-reaching point. It doesn't just apply to the civil service. There must be lots of cases where employers delegate groups of employees to particular agencies and set up separate structures.
My lady, I doubt there are very many employers who don't do that. This is, even if someone owns 2 sweet shops, they may ask the manager in each sweet shop to deal with the pay of their staff. This will, the approach of saying, well, who individually, which structure, which person sets terms and conditions, would apply to everyone. And it is completely inconsistent with the general approach taken in both by the Court of Appeal and the EAT that generally common employment is enough. It's fundamentally inconsistent with the purpose of Article 157. It allows the employer to choose whether or not it is subject to Article 157, which the courts have repeatedly said should not be the case. It allows something, and I'll come to Enderby after lunch, but it allows different bargaining processes, which is not good enough to provide objective justification, but it allows something that's not good enough to provide objective justification to stymie a claim in its entirety. And that simply cannot, in my submission, be correct. Now, I'm going to move next to Armstrong, and my Lady Arden's decision, but I'm going to look at that in some detail. I'm not sure, my Lord, if I should do that now or after lunch. I've made fairly good time.
We could probably make a worthwhile start on it.
My Lord, yes, it's at page 119, sorry, paragraph 119 of our written case, page 141 of the bundle. We've made some detailed written submissions. I just mentioned them for the court's note. But the key facts in Armstrong are somewhat complicated, but essential to understanding the decision. Armstrong is at 447, MS 447, but it concerns claims brought against the Newcastle upon Tyne NHS Hospital Trust, which is referred to as NHT in the report. And that was created in 1998 following the merger of 2 smaller trusts. And as a result, it became responsible for 4 hospitals, including the Royal Victoria Infirmary, or the RVI. Now, the comparators in this case were porters at the RVI who were predominantly male and had a bonus. The claimants were domestic ancillary workers, most of whom were female. The relevant part of the decision only concerns those claimants who didn't work at RVI, who didn't rely on domestic law, and instead were relying on single source. But on the facts, the disparity between them and the RVI porters had not been created by NHT. And that's because the bonus had been created years earlier, following departmental negotiations, before the NHT or its immediate predecessor had even existed. And the bonus had been removed from the domestic ancillary staff following a competitive tendering exercise, compulsory competitive tendering exercise in 1985, again, years before the NHT or its immediate predecessor existed. So on the facts, the disparity hadn't been created by the NHT, not because it was created by an internal department at NHT, but because it was done in the past by someone else. And one factual matter that's important to understand, part of the decision is, since the merger, it had had some involvement in relation, or some activity in relation to those terms, because it had sought to phase them out by ensuring that they did not apply to new joiners. I think the expression, they were being left to wither on the vine. And that's the background to the case. Now, going to my lady, Lady Alden's judgment, at 451, at paragraph 10, my lady said, thus, to constitute a single source for the purpose of Article 141, it's not enough for the non-RVI claimants to show that they have the same employer as the comparators. They must show that that employer was also the body responsible for setting the terms of both groups of employees. And that's straightforward, but we say a straightforward answer to that question in this case is that Asda was the body responsible for setting terms and conditions, because everyone who had any role in terms and conditions was an employee of Asda, acting in accordance with instructions Asda had given them. At page 453, at paragraph 21, the judgment turns to this wrong comparator issue. I say it's only the wrong comparator for those who weren't working at the RVI. And there were 4 issues which were determined by the court. A1 was simply an analysis of the decision of the employment tribunal. It wasn't dealing with issues of law, simply trying to work out what the employment tribunal had decided. And the question was, did the tribunal hold that the employment of the non-RVI claimants and the comparators was not attributed in the post-merger period to a single source of employment for the purposes of Lawrence, and give its reasons for that conclusion. The second question, A2, if so, was that conclusion against the weight of the evidence? Pausing there, the first 2 questions addressed really are questions of fact, and whether there had been, first of all, a sufficient decision, and secondly, whether that decision was against the weight of evidence. The legal issues are at A3 and A4. A3 says, as a matter of law, could NHT successfully contend that there was no single source for this purpose once there was evidence that it had taken some part in pay negotiations relating to both groups of workers? And that in particular, as I understand it, was a reference to the negotiations leading to the prospective phasing out of the bonus for the new employees. And then the fourth issue is, could NHT constitute a single source of employment if it only adopted the pay disparity created by former separate employers rather than created it itself? And they're the four issues that were raised. Issue A1 is answered at paragraphs 27 and 28. And in essence, it simply analyses the paragraphs of the Employment Tribunal decision and reaches the view that they did consider the question and give reasons for holding that there was no single source. And it doesn't go beyond that because that was the only issue there being considered. The second question is...
If I can interrupt you there, Mr. Short, might we return to the second question after the short adjournment?
My lord, yes, I'll do that.
Very well then, we'll adjourn now and resume at 2 o'clock.
Okay.
Thank you.